Welcome to this conference hosted by MS Focus, the Multiple Sclerosis Foundation. I'm your host, Sarah Tedesco, Social Media Coordinator for MS Focus, and I'm joined by Adam Gumson, who will be talking to us about everything you wanted to know about estate planning, but were afraid to ask. After a presentation from Adam, we'll open it up to your questions and comments. Now, I'm delighted to introduce our speaker. Adam S. Gumson is the principal attorney at Jupiter Law Center, a private neighborhood law firm which has been solving its clients' problems with integrity and compassion since 1988. After graduating from Duke University in 1988 and the University of Florida College of Law in 1991, and spending just enough time with a large commercial law firm to confirm that the corporate law firm mentality wasn't for him, Adam joined his father, Richard P. Gumson, at Jupiter Law Center in order to build a friendly, family-oriented practice to handle a variety of its clients' legal needs. Adam still loves the feel of a neighborhood law firm, even as the firm has expanded its staff and reach to support clients from all over the state, many of who live outside of Florida but have legal issues in Florida. His involvement in numerous activities since he joined the firm in 1992 has kept him connected to the pulse of the community, enabling him to better and more efficiently serve his clients. Adam and the team at Jupiter Law Center educate families and give them peace of mind by answering their questions, explaining the legal process, and creating the documents that help them. We're pleased to have him join us to present this important topic. Adam Gumson, thank you for being with us, and I'll turn it over to you.
Thank you, Sarah, and thank you to everyone who's on the call and who may listen to the call in the future. Today's talk is intended to be both informative and interactive, so that if you have questions, feel free to chat and write them, and I'll try to get it to as many as we can, if not all of them. When clients first come to see me about estate planning, one of the things they often will say is, I don't even have an estate. And I kind of smile because we all have estates. They may not be the size of Rockefeller or Kennedy, but whatever you have is what you have. And so a lot of clients want to talk about what happens in the event that they're incapacitated or they pass, especially if they have a special needs or beneficiary who may have some illness. And I recognize today we're talking to a group regarding MS. My wife is in that club as well, and I'm sure there are some other situations where you're in a club that you're not interested in being in at the beginning, but you are. So when you have a situation where you have a family member who has some illness or syndrome, one of the things you want to do is pass funds or money to them without impacting any of the government benefits that they may have. So when someone comes to see me initially about estate planning, first thing we talk about is avoiding the probate process. The probate process, for those of you not familiar with it, is how the court transfers assets to beneficiaries. And the first thing you need to know is that you can avoid the probate process for free in many ways without engaging an attorney. The ways you avoid probate for free is you either own things jointly with someone with rights of survivorship, or you have different accounts which have specific beneficiaries designated on them. For instance, you may have a checking account, a savings account, life insurance, 401k, IRA, money market, all of which you can have a designated beneficiary. So if A dies and B is the beneficiary, B receives those funds without having any need to go through the court process. The reason you have to go through the court process is if there is an account that doesn't have a beneficiary. So say you have a bank account at Bank of America with $20,000 in it. Bank of America doesn't know who to give the money to. So if you are the spouse or the sibling or the child of someone who has passed, and you show up at the bank and say, I'm here to collect mom's money, I was the sole beneficiary, the bank has no idea who you are. And the bank has no idea that if it pays you the money is in that account, that there's not someone down the road who shows up who is really the beneficiary. And then the bank would have to pay twice. So the probate process is designed to ensure that the person who receives the funds is the right person. Same thing with things like selling a home. You may own a home jointly with your spouse. If he or she passes, you're the rightful owner. There's no need to go through probate. But if you're the surviving spouse and you pass, then there is a probate need. And a lot of people will ask me why. They'll say, well, mom and dad owned the house. We've got 3 kids. We're the beneficiaries under the will. Mom and dad had the foresight to have a will. Why should we have to go through this process? And for those of you who don't know the answer, this could be very insightful, because there's a misconception in society that if you have a will, you avoid probate. And one of the things I talk about when I meet with clients or do these kinds of lectures is that it's not the will itself that helps avoid probate, it's how things are titled. So if you have a mother and father who own a house jointly, when A dies, B becomes the owner. There's no need for probate. B is already on the deed. But when B dies, B is the sole survivor. Then if the kids wanted to sell the house, they would need to go through probate. You say, why do they have to do that? Will says they're the beneficiary. Yes, they're the beneficiary. But if you've ever bought or sold a house, you've probably sat in someone's conference room like the one I'm sitting in, and you've sat at a table where there's a buyer and a seller. And the buyer and the seller sit with a title agent. And that title agent's job is to make sure that the title agent can give good and marketable title to the buyer. So when there is an empty chair at the closing, when the seller's chair is empty because mom and dad are gone, the title company needs to confirm that the person sitting in that seat on behalf of the seller is the right person, has been appointed by the court as the personal representative of the estate, has the legal authority to act on behalf of the estate. So anytime I have a client whose family member has an empty chair at the title closing, there's going to be a need for probate. The title agent will require a court order naming someone to be the personal representative, so that that personal representative has the vested legal authority to sign papers on behalf of the estate. Anytime someone passes with a property in his or her name without there being a designated other person on the deed, then there's going to be a probate proceeding. Most people who come to see me either have heard about probate and think it's a dirty word and want to avoid it, or are just scared about the costs of probate and would like to avoid it. And so one way to do that would be to have either designated ownership, or another way would be to have a deed that transfers the property either upon your death or during your lifetime into a living revocable trust. Then at your death, the living revocable trust owns the property. And so you no longer own it. There's no need for you to have a probate of your estate. And now the living revocable trust, which continues after your death, has a successor trustee after you pass, who has the legal authority to act on behalf of the trust and sell the property. So one way to avoid probate when you own a house, if you don't have a spouse or other co-owner with joint ownership, is to transfer that property eventually into a trust so that your family avoids the probate process. Another way is to have a deed prepared, just like a payable on death bank account. So you're all aware that you can have an account in your name with someone else as a beneficiary. You go to the bank, you set it up, it's your account, no one else can access it. But the bank asks you what happens when you pass. You say, I want it POD, payable on death, or TOD, transfer on death to a particular beneficiary. Then when you pass, that beneficiary shows up at the bank with a death certificate, and the bank transfers the money to that particular beneficiary, and there is no probate necessary. If you die with a bank account in your name with no designated beneficiary on it, the bank will require somebody to go to court and submit an order telling the bank who the proper beneficiary is. All the time when there's no beneficiary on an account or no co-owner of a house, probate will be required. Most people I speak to want to avoid that possibility for their family. The cost, the delay, the bureaucracy of dealing with the court system. And there are ways for you to do that. If you haven't checked your bank accounts recently, I would suggest that one of the pearls of wisdom from today's talk would be to make sure that you have all of your accounts with designated beneficiaries. Most of you who have set up an account probably did so correctly many years ago when you sat with a bank teller and he or she typed the information into the account. But I'll bet someone a quarter that when you left the bank, you thought everything was fine, and now it's X years later, and you don't have a copy of anything in your file showing who your beneficiary of the account is. And here's what's happened in the last 5 or 10 years. Many banks have merged. Some banks have gone out of business or been deregulated. My office used to be next to Barnett Bank, if anybody remembers that from 15 or 20 years ago, an old, great community bank. Barnett Bank was purchased or merged into Nations Bank. Nations Bank was purchased or merged into Bank of America. So right now, if you set up an account 20 years ago at Barnett Bank, your money's at Bank of America. It's safe, but there's no beneficiary designation form anywhere in Bank of America's folder. They don't have a folder. Everything transferred electronically. So although your money is still at the bank and you still get statements saying that your money and your accounts are what you think they are, if and when you pass, your family is going to be surprised if there's no beneficiary on that account. Why? Because only the electronic information transferred as far as the money, none of the internal paperwork transferred. So any of you who have set up a bank account years ago with your spouse, with your sister, with your kids, with your cousin, thinking that you had done everything correctly, you probably did, but it's worthwhile checking now to make sure that you have a designated beneficiary in those accounts. For many of you, that's all you'll have to do from a financial planning and estate planning protocol, because many of you will have multiple different types of accounts: checking, savings, money market, CDs, 401ks, IRAs, life insurance. They all have beneficiaries. Part of the checklist that we give clients when they come in is to make sure that every one of their accounts can be traced to a specific beneficiary. And it's not a bad idea to diary somewhere in your checklist system to revisit that every couple of years, because if your parents were beneficiaries when you're in your 30s and now you're in your 60s, there may be a reason to change those beneficiary designations. That's very important, because most of the cases we have where someone has to go through probate is a result of someone not just dotting I's and crossing T's. They could have avoided it, they should have avoided it, but there's an account there that just didn't have the right designation. That may be all you have to do for some of you who don't own property. For those of you who own property, the ultimate next step is to figure out how you want to transfer your property to designated beneficiaries. And like I said before, doing a deed to a specific beneficiary on death, or to your trust during your lifetime or on death, as a way to avoid probate. So those are some very simple things to avoid probate. Many people ask me about a living revocable trust. And if you go online or done some sleuthing research-wise, you'll you'll find that revocable trusts used to be something that only the wealthy had, and that the middle class and the lower class of income people didn't consider. Now, with the internet and people understanding, I think, a little bit more about how things work, and with the generations getting older, some of you have gone through either a probate process or a trust administration for your grandparents or your parents. And many of our clients in their 60s and 70s have told me, we did this for my mom or my grandmother or my aunt. We went through the probate process. I want to make sure my kids don't do that when we pass. So people are a little more savvy and sophisticated these days than maybe they were 15, 20, 30 years ago when I first started practicing. When I used to tell people about trusts 20 or 30 years ago, many clients' eyes glazed over as, that's too much planning, I don't need that plan. Now, these days, people understand that there is a time and a place to have a trust, and it depends on a couple of things. It depends on the nature of your assets, and it depends on who your beneficiaries are. If you have one son or one daughter who's stable and in a good job and has funds, it may be very simple just to have a deed transferring that property to that child upon your death, and you may not have to consider a trust. But some of you may have spouses or children or nieces and nephews or grandchildren who have their own internal problems. Either they have marital problems, they have financial problems, they have medical problems, they may have addictions with drugs or alcohol or gambling. And under those circumstances, you may not want to vest them immediately upon the moment of your death with a certain asset. You may want someone to protect those funds for them so that the money doesn't go directly to them unless and until the coast is clear. There are reasons when people come to see me to talk about trusts that you want to put the money away and have it protected from creditors of your beneficiaries. So that if your son or daughter has a $10,000 MasterCard debt, that the moment you die, MasterCard doesn't seize it from their bank account, that the monies are protected. So much of what I do when speaking to clients about their estate planning is delve deeper into their family relationships and who they want their beneficiaries to be, because under those circumstances, there are reasons to protect the funds as opposed to an outright distribution. We talked before about those who have debilitating illnesses. And one of the things that you have to consider is, to the extent that you have a beneficiary who may need Social Security disability or long-term care or Medicaid, that you don't want to dump a ton of money into someone's name at a time when they say, no, don't give it to me, I don't want it right now. You may have a child whose children are going to college, and the child is applying for financial aid for their child's college. The worst thing you could do is dump a ton of money into their name at a time when they're like, don't give it to me yet. You have situations with divorce. I also handle divorce matters, and marital monies are constituted from assets that you earn or income you earn during your marriage. But an inheritance in Florida is not marital. An inheritance belongs to the inheriting party. So one of the things you want to avoid is giving someone by an inheritance money that can be used by the other party's spouse, or have the other party's spouse claim, oh, you now have money in your own name. So in the event of a divorce, you don't need alimony, or you don't need assistance with paying attorney's fees. So if anybody has questions on those matters, those are the kinds of things that come up in estate planning, even though they're unrelated to the estate planning. Your marital situation, your kids' marital situation, your grandkids' marital situation all have an effect on how you handle planning. Sarah, I don't see any questions, so if there are, I'm not showing up on mine. So I'll keep going unless anybody has particular questions that you see. In addition to wills and trusts, one of the important things that people tend to limit or forget about are things like advance directives. Advance directives are things like durable power of attorney, healthcare surrogates, living wills. Those three documents in particular are documents that people sign to permit others to make decisions for them if they're incapacitated. They are not effective upon death because then someone's will or trust take over. So they're only good during someone's lifetime, and they permit people called the attorney in fact or the healthcare surrogate to make decisions when there's an incapacity. So to the extent that someone's in the hospital, has a heart attack, a slip and fall, for whatever the reason, can't at the moment make a decision or sign documents on his or her own behalf, the power of attorney and healthcare surrogate permit a designee to do those things. For instance, I'm on the way to close on my house. I'm buying a house today. And on the way to the closing, I get in a car accident. I'm temporarily incapacitated. If I can't sign those documents, I can't buy the house unless I have a power of attorney who can sign for me. So whether I'm selling or buying a house, if you're incapacitated, you're stuck if you don't have someone who can stand in your shoes and sign documents on your behalf. From a medical perspective, whether we're dealing with COVID, whether we're dealing with some other medical issue, to the extent that you're incapacitated and can't act for yourself, a healthcare surrogate permits someone to make medical decisions for you. Speak to doctors, give consent to treatment, get access to records, apply for benefits, transfer you from facility to facility, enforce or not enforce a living will. These are all items that you'd want someone to act for you if you are incapacitated, because the alternative to not having a healthcare surrogate is to have someone go to court and try to be appointed as your guardian. And guardianship proceedings are things that you'd want to avoid almost at all costs. To get involved in a guardianship proceeding would cost thousands of dollars, take days, weeks, sometimes months to slog through the system. And then if you have money that is allocated to you, you have someone who's managing those funds and court auditors who are responsible for reviewing all transactions. Most people would want to avoid a guardianship situation if they could. And what the healthcare surrogate does is permit someone to act for you without having to go to court to get permission. So those of you who are married would likely name your spouse. If you don't have a spouse, maybe a sibling, a child, a cousin, a good friend, someone you trust to make those kinds of decisions. Oftentimes I'm asked by families who have children, I've got 3 children, I love them all, how can I name one over the other? And it's a function of who would do the best job, who would act like you would act if you could. So that means you may not necessarily name the oldest. You may not necessarily name the only boy or the only girl. You know, people come to me with all sorts of rationalizations about how they chose the person to act. And I'm usually the one to say, well, who would make the decision? You would. Don't name someone just because you're afraid of ruffling everyone else's feathers if they're not named. Name the person who will do the best job and who would likely make the decisions you would make if you were not incapacitated. So documents like the durable power of attorney, the healthcare surrogate, the living will are all documents which permit someone to make decisions during an incapacity. After the incapacity is over, then you may not need that person to act any longer. So what it is it's a legal Band-Aid. It's a Band-Aid permitting someone to make decisions without having to go to court. And if the situation that rendered you incapacitated is removed and you're back to normal, then that person doesn't need to act any longer with respect to either financial or medical decisions. If your medical situation worsens and you pass, then your power of attorney and healthcare surrogate are no longer valid. They're not effective. And whoever's in charge of your will or your living revocable trust is the person who's in charge, either as the personal representative of the probate estate or as the trustee of your living revocable trust. Most people who do estate planning will do a package of documents because the documents each speak to a different situation. So for instance, when my grandparents would have done planning 30, 40, 50 years ago, they would have done a will because that was the predominant document that everyone knew about and everyone did. There were no powers of attorney. There were no healthcare surrogates. There were no living wills. What has happened in the last 50 years has been basically an explosion of technology that has permitted the medical community to be able to keep someone alive almost indefinitely, almost forever. And so when I was in law school, some of you may remember Dr. Kevorkian, who was assisting people with end-of-life decisions and was arrested on multiple occasions for doing so. That was before living wills. That was before euthanasia became something that became a privacy right and a personal right. And these days, every hospital in America has the ability to enforce or permit patients to enforce living wills so that you don't have to be artificially prolonged on a respirator or force-fed through intravenous methods. The living will gives you the right to say how and when you want treatment or when you don't want treatment. And the person you name as your healthcare surrogate is the person who would be responsible for making or not making the decision to enforce the living will. So when you talk about simple estate planning, you're talking about having a will, having a durable power of attorney, having a healthcare surrogate, and a living will. Those are what I would consider to be needs. Most people would need at least those documents. If you own properties, then you might consider preparing deeds like we talked about before to transfer the properties to specific beneficiaries or to a trust. For those of you who have greater wants and want to protect beneficiaries from either outside sources like marital, medical, or financial situations, then the trust is another want. So when people come to talk to me about estate planning, we talk about needs and wants because everybody's situation is different and everyone's budget is different. Not everyone has the funds to do all of the planning we're talking about, but it's good for you to know about it because you may not do it now, you may choose to do it in the future. Any current questions on that before I move on to topics? I don't see anything in the chat room. So another topic we often talk about when we talk about everything you always wanted to know about law is in the marital context. In the marital context, the divorce rate currently is somewhere between 55 to 60%. And that's of people who choose to get married, not people who are living together. So you can imagine what the actual breakup rate is. It's going to be higher than that. The reason that's important to know and how it relates to estate planning as well as divorce is that If the divorce rate is 55 to 60%, flip a coin, you or me is getting divorced. I don't wish it on you, but I sure don't want it to be me either. So one of the things we talk about when we talk about divorce and marital rights are how does the court dissolve a marriage and what are the main issues? When people get divorced, if they have children, usually the children are the largest issue in the case. If they're minor children, we have to talk about things like where are they going to live and how are they going to be supported. There's a time sharing schedule that's instituted by the court. Those of you old enough to remember the old movie Kramer versus Kramer with Dustin Hoffman and Meryl Streep from the 70s, remember that they were fighting over custody, who has possession of the child. In Florida, the word custody has been stricken from the statutes. We no longer talk about custody and possession of the child. We talk about time sharing with either parent. So when someone gets divorced, the court is going to require that there be a parenting plan that implements time sharing requirements for each party. So each party is entitled to time sharing with his or her child. And there's a schedule as to when the child sees mom, when the child sees dad, holiday schedule, things like summer break, spring break, Thanksgiving, winter holidays. All of those things are documented and memorialized in a parenting plan so that there's no disputes about, I'm at the airport, I'm supposed to fly out a holiday, and now who gets the child? It's all documented. As far as support is based upon the Florida Child Support Guidelines. And there are specific formulas involved for how child support is calculated, basically on income. So if you have two parties and one party earns 70% of the income and the other party earns 30% of the income, there's basically a guideline with a chart, one child, two child, three children. And it's sort of one of these with the income on one side and the amount of kids on the other. And you find how much income both of you earn, how many children you have, you find the intersection of that chart, and that's the amount of child support that's owed, and each party pays his or her pro rata share of it. So child support's a function of how much money each party earns, and each party has a requirement to support his or her child. You may have heard of agreements where one party says, I will permit you to pay less money in return for you not seeing the child or only seeing the child on certain days. You can't contract away the child's right to receive child support. So although you may have a signed written agreement that's notarized by multiple people, you can't waive child support because the case law and public policy is a child has a right to be supported by both parents. And it's not the parent's right to contract away the child's right for child support. It's the child's right to receive it. So those of you who have submitted or have done an agreement that says, I'll waive child support in return for something else, if you ever had to go to court to enforce that, then under those circumstances, the court would not enforce it. It's against public policy. So to the extent that you have children, the child support guidelines are based upon the overnight time sharing that each party has. So the amount of overnights that each party has is figured into the formula. And it kind of makes sense. If you have one party living in Alaska who never sees the kids, and the other party living here in Florida and is with the kids all the time, it makes sense that the overnights are calculated because you're going to spend more money when the child is with you than if the child's never with you. And so the formula credits each parent for the amount of time he or she spends where the child's spending overnights with them. There's also in a divorce matter issues regarding personal and real property. And we call that equitable distribution. Equitable distribution means we try to split assets fairly amongst the parties. Everything that's acquired during the marriage is called a marital asset. And a marital asset might be bank accounts, a house, a car, art on the wall, jewelry given to each other during the marriage, whatever is acquired during the marriage. And in a perfect world, that would be sort of a 50-50 split. Everybody would get half of what was acquired during the marriage, irrespective of what you contributed in income to the marriage. One of the misconceptions, I think, in divorce cases is where you have someone who says, I earned all the money and you earned none of it, so all the money in the bank is mine. Courts don't work that way. Courts have never worked that way, even in the traditional marriages of the 50s and 60s and 70s, when it was quite traditional for men to work and women to stay home. Even in that scenario, the courts always viewed what was in the bank and what the marriage had acquired as a marital asset owned equally by the husband and wife, irrespective of their financial contribution. So in the old traditional view of marriage, if you remember the Cleavers, Ozzie and Harriet Cleaver, I think it was, he may have worked all day and she may not have worked in a traditional sense of the job, but she was home with the kids and did the cooking and the cleaning and entertaining, and when he brought his boss home, she made dinner. In that sense, she didn't contribute financially. But what the courts have always said is, even that spouse who's not working for a living, making money, is enabling her spouse in that example to go out and do all the things that he's doing because she's responsible for other things. So often I'm asked by either the wealthier party or the non-wealthier party, where do I stand with respect to assets? And you're going to get a fair shake of assets because Florida law is that you're entitled to an equitable distribution of the assets. There are situations where people don't get exactly 50-50, and you can think of reasons why. If I had $100 in the bank, but immediately before filing for divorce, I took out 90 and hid it, and we only had 10 left, it wouldn't be fair to split that 5 and 5 with my spouse. So equitable means fair. It's not 50-50, it's fair. And so those parties who wheel and deal and move things may not get 50% of the remaining assets because there are assets that are hidden that should be added back to the account before splitting. So equitable distribution is the situation in which both parties are entitled to a fair and reasonable share of whatever the marital assets are. There are some marital assets that are not included in marital. There's some assets that are not deemed marital, and they're either non-marital or premarital. If I have $50,000 in the bank and I leave it there and get married, never touch it, never commingle it, and years later that 50,000 is 100,000, it may all be mine. And my spouse may not be entitled to it because it was not a marital asset. If it's commingled, it may be that it now becomes a marital asset. So when you go through a marital divorce situation, you have to be able to analyze all of the assets and be able to trace them to their original source to figure out who owned what before the marriage and how did things appreciate during the marriage. There's a difference in divorce between an uncontested case and a contested case. Uncontested are cases in which families have agreed on how to resolve all of their issues, whether it's children's issues, whether it's financial issues, whether it's things like alimony or other financial issues. And if it's uncontested, there's usually an agreement that's drafted. And once the agreement is drafted, it's submitted to the court, and you may not be going back and forth in litigation. To the extent that you can't agree with your spouse, things are said to be contested. And contested cases, if not resolved, will be tried before the judge. I forget the percentage, but it's somewhere north of 95% of all cases settle before there's a trial. So not every case that starts out contested ends contested. Many resolve themselves through negotiation or mediation. And only the very, very small percentage of cases where the parties are so far apart that they can't split the baby in half or otherwise come up with some reasonable solution, those are the cases that go to trial. All other cases somehow find themselves short of trial by resolving them through the negotiation process. And for most people, they want to avoid court. Very few people come to see me and say, I'd like to spend 6 months or a year in contested litigation and spend thousands of dollars and at the end be miserable. And be miserable for the next 6 to 9 months as we litigate. Litigation is not fun. And so very few people want to spend money unnecessarily if they don't have to. And so under those circumstances, you as the litigant have the ability to choose how to settle a case. And if you're reasonable and the other party is reasonable, you'll never see the inside of a courtroom. So if I had $100 and I said, how do you want to split it? And we both agreed 50-50 was fair. We don't need any assistance in figuring out how to split that up, even 55-45 or 60-40 for whatever reason. Most of the time cases litigate, it's because one party thinks that 90-10 is a fair split. And the other party thinks that 10 to me is not fair. So under those circumstances, those are cases that have to be litigated because one party is taking such an aggressive stance that the other party has no reason not to shoot for the fences, because why not if you're only being offered 10%? I see a question regarding, do most states have similar types of laws regarding marital assets such as Florida has? And the answer to that is, one, I'm licensed in Florida and Florida only. So what I'm telling you applies to what I know about Florida law. However, generally, I think that the state's laws are fairly close in that most states would view a marital asset as something that has been acquired during the marriage, or that you do during the marriage to make something appreciate. For instance, if I took $100,000 that is my premarital money, and I quit my job and I day trade every moment of the day, and I spend no time working during the marriage, but only managing that one $100,000 asset, and I turn it into $500,000, I would think that my wife would have an argument that my marital labor increased the value of the asset such that she would be entitled to some of the appreciation. So marital assets typically are those acquired during the marriage, but there can be other types of arguments, even as to non-marital or premarital assets, because otherwise you could have people who are working during the marriage that don't have an incentive to share with their spouse. And so raises a good point around why people have prenuptial agreements or postnuptial agreements. So in Florida, once you get married, all of the assets that are acquired through your income are deemed to be marital. So under those circumstances, if I earn all the money and my spouse earns none of it, and we have $100 in our account, she's entitled to 50 of it, even if she didn't earn it, because that's what marital assets mean. Income is marital. A prenuptial agreement would change that. A prenuptial agreement would say, to the extent that I earn money during the marriage, I could seek to segregate the money I earn as my own non-marital money. So my $100 is mine, my spouse's money is hers, and we don't consider our income as marital, or we don't consider other sources of income as marital. So to the extent that you have two parties who are earning an amount of money that they want to be responsible for solely on their own, they could say, we want to keep our income separate, and we don't want to have marital assets. One of the reasons to have a prenuptial agreement is to be able to safeguard the monies you earn or the assets you've acquired for not only your benefit, but perhaps for your estate benefit. Because Florida law is that when you pass, if you pass without any estate planning in effect, that your spouse is entitled to a share of your estate. A prenuptial agreement says your spouse is not entitled to a share of your estate unless you subsequently agree that they are. So if I were getting married today, I might have a prenuptial agreement that says my spouse gets nothing. But if I'm married 20 or 30 years in a happy marriage, I may change my will or my trust down the road to give my spouse a share. There's nothing that prevents me from giving my spouse a share. It just means that she's not automatically entitled to one. Most of the prenuptial agreements that I handle are for senior citizen clients or clients in their 50s or 60s who have acquired some wealth. You don't see too many 18-year-olds out of high school who need prenuptial agreements because they don't have any assets. They have nothing to protect. But if you're 75 years old and your spouse has passed and you have a house and multiple accounts and you have children, then the reason for you to protect your children is that you have a prenuptial agreement to protect their inheritance from a new spouse you only know relatively recently. So it might surprise you to know that most of my prenuptial clients have as gray a hair as I do, or even grayer, because they're the ones who have spent their lifetime acquiring assets and want to protect it for the benefit of their children or grandchildren. So it's not unusual to have a situation where each of the parties in a prenuptial agreement has acquired their own assets and wants to make sure that what he has is his and what she has is hers. And what they acquire together or what they buy together becomes theirs together. In that sense, the prenuptial agreement protects each party from not only their spouse, but their spouse's family in the events of divorce or death. Some questions I'm going to get to. There was a question about someone asking if they wanted to begin the process of hiring an estate attorney. What would be my first step? And obviously it depends where you are locally. I am from an old school background that says referrals are still probably the best way to find a qualified professional, whether it's an attorney, a doctor, an accountant, a plumber, an electrician. I mean, I'd still rather have a friend tell me who they use than try to search out through the internet. But however you find someone, I think that what you want to do is be able to sit down with someone and have them explain the basics to you, and not talk over your head. Make sure that you understand the planning that he or she is suggesting, and that someone gives you some options as to things you can do. There are many clients I've known over the last 20 or 30 years who I've given options to, and many people choose how to handle their estate planning by virtue of fee, what things cost and how much I have and how much I want to devote to this particular problem. As people get older, their goals change, and they go from I want to do the bare minimum to I want to do some things to protect my family. And so when you're choosing an estate planning attorney, I think as long as you have a comfort level with him or her, and that you feel like they're giving you all of the answers to your questions, that's how I would start. If you don't have a referral, local bar associations have lists of people. Certainly the internet is helpful to be able to look someone up and get a feel for who they are by virtue of their website. Some attorneys will charge consultation fees to meet with clients. Some will do free consultations to assess your situation. So those are some answers to that. Let's see another question. Question is, I have a family member that passed and I was named in will for 10% of the estate. It's been 2 years and still monies have not been distributed. Is there a limit on how long it can take to probate a will? The answer is maybe. I don't mean that to be evasive. It is impossible for someone to tell you how long an estate will take to be probated without knowing details about what the assets are and what has to be done. For instance, when someone dies, let's assume I'm handling the probate for the personal representative. The first thing we have to do is be able to find out what the assets are. That may sound simple in just making a list, but oftentimes I find that the personal representative doesn't have a good idea what the person owned. And if the personal representative lives up north, it may be a week, a month, or two before they can even come down to the house to get an idea of what's in the house or to get mail to figure out statements. These days, with a lot of statements coming online, you have situations where you don't know the password and you have no idea what someone's holdings are without doing some major sleuthing. Even after you identify what the assets are, understand that there's not going to be any distribution to beneficiaries until all of the estate bills are paid and all of the tax issues are resolved. So even the most simple estate, let's assume you have a house and some bank accounts and you sell the house, liquidate all the bank accounts and have an estate bank account that has all the money in it. Before you can distribute the money as the personal representative to the beneficiaries, you have to make sure that all of the claims have been paid and you have to make sure that all the tax issues are resolved. Otherwise, if you let the horse out of the barn too early and you distribute all the money and find out that Uncle Sam is owed money or a creditor is owed money, you as the personal representative have some personal responsibility. So under those circumstances, it often takes a year plus to be able to walk through some of those issues. Take today, for example. It's July of 2020. And if someone were to pass, they have income from January 1 through July 2020 that has to be accounted for, and Uncle Sam has to be paid for whatever the income is, the taxes are on that income. Well, no one's filing a tax return for that person today. Usually tax returns are filed by April of the following year. So a tax return is probably not going to be filed in another 6 to 9 months to be able to identify what the taxes owed are. Imagine someone who has dividends on accounts or has businesses that have moving parts. So your question about 2 years later, monies haven't been distributed can be a function of assets that still have to be marshaled, sold, liquidated, monies that still have to be paid. And in many cases, the person who is the personal representative doesn't have real motivation to resolve things quickly. So if you've got a child who's the personal representative who has been appointed and lives up north, and it may take them months to come down here to deal with the house and clean it up and have it painted and have it ready to be sold, you're going to have months and months of delay where nothing's happening and you've got carrying expenses that have to be paid just to carry the house. So without knowing specifics of the assets, it's harder, it's almost impossible to say this is what should have been done in that estate. Next question, a married man's sole and separate property in regards to a home. I have seen this wording while working in insurance. How would he maintain this status for the home? I'm not sure I understand that question. I'm not sure if when you say a married man's sole and separate property, you're talking about language in a deed or in an agreement or somewhere else. So I'm gonna skip that, but I'm gonna come up with my own question, and I think some of you may want to look at the language in your deeds. I find that a lot of people have bought a property, but don't know how they own title. So this is hopefully another pearl of wisdom that will help someone out there. When you go to a closing and you are the buyer and you sit across from the seller, typically the seller signs a lot of seller papers and the buyer signs a lot of buyer papers. And there's only a couple of documents that are signed by both the seller and the buyer. So when you, as the buyer, leave the closing, the deed is in the seller's pile. And the deed is taken by the title agent and recorded at the clerk's office. And it usually takes a couple of weeks to a month to record that deed. And hopefully shortly thereafter, you receive in the mail the recorded deed to your property. And for many people, if you've gone to a closing without an attorney, it may be the first time you've ever seen that deed. And you don't really know how you took title. For instance, let's assume that you have A and B who are a boyfriend and girlfriend who are buying a property together. And the title company prepared the deed. Maybe the title company prepared the deed as A and B as joint tenants with rights of survivorship. Or maybe the title company prepared the deed as tenants in common. Those are important legal terms that unless you know to ask the title company, you might get a deed with one or the other without having had any input on which one you really wanted. Joint tenants with rights of survivorship means that when A dies, B is the owner. When B dies, A is the owner. So it is last man standing gets the property. That may be fine for your situation. Tenants in common means when A dies, A's share goes to A's heirs or A's people. And B's share, when B dies, goes to B's share. To the extent that you own something as tenants in common, that means that you could have two potential probates. So if you can see here, you got A and you got B. A dies, it goes to A's people. B dies, it goes to B's people. You have heard of situations where some farm in the Midwest is owned by 27 cousins, from great-great-grandparents. That's how it happens. You've got A, B, C, D, and E, and they each have kids. And so their kids and their kids' kids own a 1/50th share of something. It's not that tenants in common is wrong. It fits a particular situation. For instance, you're both 70 years old, you're getting married, and you want to buy a piece of property, but you're putting your half contribution to the down payment, and your friend or spouse is putting their half. And you want your half to go to your side of the family, and his or her half to go to her side of the family. That's a perfect situation for tenants in common, because that means each side gets their respective parents 50%. But that doesn't solve the situation if you're trying to avoid probate. Probate would be rights of survivorship. At least at A's death, there's no probate at A's death. We've still got the problem when B passes, but B can do something similarly. So if you own a piece of property, it might be wise for you to pull out your deed and verify how you own the property. Some of you may be surprised to see language in the deed that you didn't expect to see or that you didn't ask the title company to put. It could be as simple as the last deal the title company did before your deed had tenants in common, so they just copied and pasted the same language into your deed, even though you didn't need it or want it that way. Check it. The time to fix it is now, as opposed to discovering it when someone passes. Okay, There was a question about if someone is unmarried without children, is there a way to hire someone to act as a financial power of attorney or trustee in case the unmarried person becomes incapacitated? The answer is yes. There are people and entities who will act as power of attorney for someone if you don't have that right person in your life. The problem is that they are few and far between in my experience. You have banks who have trust departments who are very happy to manage your money after you pass, but very few entities that will deal with the day in and day out issues that you might have before you pass. So things like, as a power of attorney and healthcare surrogate, you can hire someone to do that, but you want to make sure that they're licensed, that they have insurance, that they're not going to abscond with funds. Powers of attorney and healthcare surrogates are very, very powerful documents. They permit someone named to make major decisions for you, including selling a house or a car or investments. So you want to be really, really careful about unwittingly naming someone and finding out that you're duped by them, which is why you hope to make sure that you're naming someone that you have real comfort. So yes, there are people who do that and do that for a living. And if you don't have the right people, then they're a good option as opposed to having nothing in effect. There are clients of mine who have said, I don't have someone in mind. I don't want to name a stranger, and I'll worry about it down the road as opposed to naming someone I don't feel comfortable with. So that's a judgment call. Let's see. I think that's all the current questions right now. I still don't understand the question about the married man's sole and separate property. So if someone wants to give me some more detail on that, I'm happy to answer it. One of the other things that comes up often, it's not relating to estate planning or marital, but it's something that I'll relay to you, is all of you probably have automobile insurance. And one of the things that comes up is what's the nature of coverage that you should have? And should you have uninsured or underinsured coverage? And if you don't know what that is, in Florida, my insurance covers you, your insurance covers me. So if we're in an automobile accident, I have a $10,000 PIP, personal injury protection policy. And the first $10,000 is paid by my carrier to deal with the things that happen in an accident. My medical bills, my x-rays, those things. But once my $10,000 PIP is exhausted, I look to your insurance to pay any of my losses, and you look to mine. So one of the problems is that if you have insufficient coverage, and you are the one who caused my injury, but have very limited coverage, if I don't have something called uninsured or underinsured coverage in high enough amounts, then I may not have anything to pursue. So God forbid I'm in a car accident and I'm hurt and I need surgery or I have rehabilitation or I have future medical expenses, I may have a very sizable claim. My coverage covers you. You're not hurt. If you are an 18-and-a-half-year-old person who has a 20-year-old clunker car and has $5,000 or $10,000 of minimal coverage on the car without anything else, and you are the one at fault for hitting me, I'm out of luck if I don't have enough coverage on my policy to cover my damages. So under the circumstances, when you're involved in an automobile accident, obviously there's things like liability, who's responsible for the accident, damages, is anybody hurt? And then the third thing is collectability. is there someone to be able to pay the damages? We all would recognize that a major car accident that breaks my bones or puts me in the hospital for months or debilitates me, that clearly I have damages, I'm hurt. Let's assume for the purposes of this argument that I was at a stoplight, stopped, and someone rear-ended me. Liability is clearly upon the other party. There's nothing I could have done to avoid that accident. So liability is against the party, damages I have. But if the other party doesn't have enough insurance coverage or is not wealthy enough to self-insure, like the Rockefeller Kennedy sort of example from before, then I have to go against my own policy. And if I don't have enough coverage in my own policy, then I can't collect. And if I can't collect, it's not worth pursuing that claim. So typically when you have a personal injury case, whether it's a car accident or some other injury in which you're hurt, the personal injury attorney is always going to analyze what's the liability, what are the damages, and what's the likely collectability. If you are not sure what type of insurance coverage you have, then under those circumstances, it would be wise for you to look at your policy. You have a DEC page, a declarations page, which lists your coverage. And you should speak to your insurance agent about making sure that you have uninsured and underinsured coverage in as high an amounts as you think is wise to cover. Doesn't mean you should be insurance poor, but what it means is under the circumstances, you should have as much coverage as you would have if someone else hit you, so that if you hit someone else, you have enough coverage. So if you're hit, you have the same coverage. And why it's important is most insurance agents do not have incentive to sell uninsured or underinsured coverage because they're inviting claims against their own carrier. So they're not given an incentive by their carrier to market or encourage the sale of uninsured or underinsured coverage. So if you went into your insurance agent and said, what is required in the state of Florida? The answer is very limited. Very minimal coverage is required. And so think about all the people who are driving in Florida, whether it's college students on a fixed budget, whether it's a low-income wage earners who don't have sufficient funds to put into their insurance. All of those people are potential pinballs who, if they're in an accident with you, have limited coverage. And if the answer when your insurance agent is asked is what's required is not much, then all of those people are taking out the bare minimum of coverage. You should not. Florida is a very transient state. So to the extent you're hit by someone who has minimal coverage, the only salvation for you will be to look against your own policy to cover those damages. And if you don't have that coverage, under those circumstances, you're not going to have any ability to pursue a claim. And that's happened in so many cases where I'm called about an injury, and you've got to have some semblance of liability, damages, and collectability to be able to pursue that claim. If one of those three factors is really limited, it's going to severely inhibit your ability to pursue that claim.
Okay, that's all the time that we have for now. If you missed any part of this conference, it will be replayed on MS Focus Radio and available on demand on our MS Focus SoundCloud page or our YouTube page. Remember to follow MS Focus on Facebook, Twitter, and Instagram for times and access information. Our next teleconference will be on July 21st at 7 p.m. Eastern with Marco Vespignani on integrative strategies for MS. Our sincere thanks to all of our attendees for your participation, and especially to our speaker. Thank you so much for your time that you spent to prepare and share this information with us. Have a great day.
Thanks.